Immigration
It's one
lawyer.
o'clock.
Hi, everybody. It's Elektra Yao, immigration lawyer and entertainment lawyer here in New York City. I have offices in New York and New Jersey. It's been a while since I have been live, but I'm here to tell you that I'm going to be live every day of the week from now until December to talk about immigration issues, O-1 issues, transitioning from a work visa to a green card, and just answering questions, giving my tips, giving my best practices so that you understand the immigration process and the visa process a little bit better. I'm having a little bit trouble with Instagram. I'm going to try to sign in there again. But today I want to talk about something really, really interesting. And this is something that happens to me all the time. Um, I work on a lot of different types of cases, some cases that are really straightforward, other cases that are not so straightforward, cases of people who are maybe just starting off in their careers. So a lot of different types of cases and different types of profiles. So today I want to talk about a client who was up for her O-1 extension and had been to a lawyer previously who told her that she could not file as a photographer and as a performer. Now, I understand the nature of the arts. I understand that as an artist, sometimes you are not just confined to one discipline. Sometimes you're a multidisciplinary artist and you work on multiple different types of artistic mediums, right? And especially the O-1 visa, you're on that visa for 3 years. There's lots of things that are happening and changing. You're evolving as an artist. Hopefully you're following your attorney's advice and working within the scope of your field to develop your professional profile for the green card. This is what I always advise my clients to do. So anyway, this person, wanted to work as a performer and also wanted to work as a photographer. And again, like I said, I work on many of these types of cases where my clients are just not limited to one discipline. So most other attorneys would shy away from what I call double barreling a professional title. I do it all the time. I have many clients who serve as both performers and as influencers, for example, or who serve as performers, but also as singers, or maybe who do marketing and also serve as the talent. So many of my clients have these more convoluted professional titles. And it's my goal as the attorney to make sure that they remain in status, right? I do not want my client to file as a performer, but then ultimately do photography work. That's unauthorized employment, which will ultimately penalize her when she is going to apply for her green card. So, like I said, I work on a lot of these types of cases, and I want to just kind of run down or go through the basics of filing an O-1 petition with two professional titles, and particularly two professional titles that are unrelated. In our case today, a photographer and a performer. By the way, this client was approved. No issues with the case. I will talk about some more complicated issues that may arise, but that didn't arise in her case because of the way we argued her professional profile. So basically, the way you would file an O-1 with two professional titles is you would submit identical information. So for example, in this client's case, we included contracts for her performer work, but we also included contracts for her photography work because we need to be able to prove that she's going to be working within the scope of both fields, photography and performance. Now, since this was an O-1 extension, this was a little bit tricky because I did not want to present a case or a petition that was materially different from the previous petition, which I did not file. I guess her previous attorneys may or may not have been aware of her photography work. I'm not quite sure, but I wasn't involved in the previous petition. So I needed to include information that would not contradict what was in the previous petition. I needed to include evidence and a scope of work that did not contradict the previous petition. Yes, I did file her as both, right? She's now authorized to do performance work and photography work. So you might be saying, Elektra, how are you able to prove that photography is not materially different than performance? Well, This is when it becomes really, really important to have an attorney that is really well versed in the arts and understands the different disciplines. I myself have a photography background. I actually went to college my first year on a photography scholarship. So I had like my first group exhibition when I was like 16 in New York City. I'm obsessed with Nan Golden. I'm obsessed with Lewis Hine, particularly documentary photography. So I know a little bit about photography. So what was I arguing in this case? Again, I did not want to materially make this petition different than her previous petition, because then that would have triggered an RFE. I really needed to work within the scope of performance. So I argued that my client was an expert both in performance and what I call performative photography. So, performative photography, I argued, was basically performance, the art of performing with the photographic medium. And if you're unsure about what this means exactly, I invite you to look at photographers that we used as evidence in her case, such as Cindy Sherman. So, Cindy Sherman is a female photographer who I argued performs for the camera. So her subject matter for her photographs is herself. She dresses up as different representations of herself, representations of the female mind or the female body, and photographs herself. In my case, my client did the same thing, and she also photographed performers in their performance states. So again, I was able to frame her photographic work within the realm of performance, and I was able to support this with evidentiary support of examples of successful photographers who already do this, who see themselves as performative photographers. So not only technical photographers like maybe I don't know, Anna Leibovitz, but who see themselves really as performers for the camera, which is exactly what a film and TV performer does. He or she performs for the camera in the moving image. I argued in this client's case that she was performing for the camera, but within a still image. And I had the evidence to support it because I did a lot of research on photography and the nature of the medium and what it means to be a subject matter in front of the camera. So, needless to say, the technical requirements of the O-1, so the contracts, the advisory opinions, we had to double barrel that. We had to do that for both professions, both photography and performance. So she did have advisory opinions from both appropriate labor unions. She did have contracts from both professions, photography and performance. She did have letters of recommendation that confirmed her expertise both in performance and photography. So it was essentially one big case with two professional titles within it. And again, what I was really, really hoping for and what I was arguing for within the petition was to argue that performative photography is definitely within the scope of performance, and my client is not doing anything, or my client is not putting forth a petition that is materially different from her previous petition. So whereas her previous petitions mostly focused on the performance work, we focused on performance in the traditional sense, so like on stage acting as a performer, and performance in the multidisciplinary sense, which was this performative photography, this professional title that we inserted in her petition. Again, all of this supported by facts in history and theory in photography, and client was approved. No issues with the merits of the case. Client can now legally work as a photographer and as a performer. So what I really want to stress in an experience like this is, if you are that type of person like this client, if you are the type of person who does multiple different things, right? Think of maybe a director. Many of my clients are both filmmakers and photographers, right? Or maybe are directors and editors. They're really not limited to one discipline within their art form, right? If this is somebody like you and you really are anticipating working in both fields or working multiple hats during your O1 validity period, you really need to think about the nature of your industry and whether or not the attorney that you're working with has an understanding of both those industries and has the ability to create connections so that an officer will see that they are somehow related, right? In this case, like I said, we worked really, really, really hard because it seems at the first glance that performance and photography are not related, but our research supported the connections that we were making between performance and photography. So you want to make sure that your attorney is really aware of these nuances, because that will be the difference between an approval, an RFE, or a denial, unfortunately. So we're very happy about this case because, like I said, it's a case where the professions seem unrelated, very different than somebody, for example, who does acting and who also does maybe influencer work, which is very, very common, or someone who serves as an editor but also serves as a gaffer. Again, it's within the same industry, so it's a little bit easier to argue the nuances and the connections. But a photographer and a performer are unrelated industries unless you and the attorney put in the work to demonstrate the connections and the nuances and why they are related. In this case, because it was an extension, the important part for me was to, again, not demonstrate that there was a material change from the initial petition. But if this is your first O1, you do not have that issue that you need to deal with. You have a tabula rasa, a clean slate to argue both. I was limited because this person was previously approved on a performer O1. So I hope that this was helpful. I hope that this helps you understand really why the O1 visa is so special, that you don't necessarily need to file concurrent, so simultaneous O1s for different professions. If you're able to successfully argue the connections and your qualifications for both, you can ultimately have a professional title that is not so simple and cookie cutter, right? Like, think of a cookie cutter profession like maybe a graphic designer, or even then they're very, very complex. Maybe somebody who is like a straight dancer who only does dance. Um, with the O1, you have the ability to be malleable, to be able to construct your own world and demonstrate it and prove it to the officer. Ultimately, it's a little bit more difficult, but it's definitely, definitely possible. And I would say the bulk of my clients are in this realm of these hybrid professions where they are working in more than one field and with more than one professional title. So if you're interested in more information about the O1, about immigration, about transitioning from O1 to EB1, please follow, like my videos, and stay tuned. Every day I will go live around this time. Please feel free to send me an email so that I can answer questions live and I can help you and support you better on this process. If you want more detailed information, go to my website and download my O1 visa toolkit so that you have my steps that I use every day on my cases, so that you can further understand the process from the point of view of an attorney who understands the arts. So thank you so much for watching, and I will see you tomorrow.